Welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand a little bit more about property law. In the series, we cover 4 fundamental questions, and today we are talking about the third question, which is using property. How owners of beachfront property may use their property is the focus of today's class. Beaches are a type of property most of us consider to be public. They are great spaces for mingling and congregating, like a modern day commons, which legal commentators like Carol Rose have in fact called them. In another video, we discussed different parts of a beach: upland, dry sand, wet sand, ocean, which might provide relevant background here. In this video, we discuss 3 cases from 3 different states that illustrate the range of judicial decisions protecting public access to private property. Okay, so as you know from another video, the ways states divvy up property rights on the beach are very diverse. And so these 3 cases illustrate that point. We're going to start with Matthews versus Bayhead Improvement Association. So this is a great case. It comes out of New Jersey, and it comes out of a charming town which has which is on the New Jersey shore, and where a nonprofit homeowners type association holds fee simple title or leasehold interest in nearly all of the parcels of beachfront property on the Atlantic Ocean. The association restricts its portion of the beach to members who live in the area and have to apply for membership. The membership, according to the court, is routinely accepted. Public access is allowed on these beaches in the early morning hours, something like 5:30 to 10 a.m. The question in the case is whether the public can gain access through and use the dry sand area owned by this quasi-public body at times other than these extremely early morning hours. So the court goes through the facts and finds that dry sand, even if publicly owned, should be held in the public trust. It says that the public has a right to wet sand, and the right would be meaningless if they didn't have some access to dry sand. Moreover, in a town without a public beach, which is the case in this town, limiting membership to residents is in conflict with the public good and is contrary to public policy. So here you see a strong public policy argument for opening up the beaches. So what is the remedy in this case? Well, the court's remedy is ordering membership to be open to the association properties. It doesn't go so far as to say that the private beachfront property must be turned over to public ownership. It basically assumes that opening the association and membership in the association will be enough to satisfy the public need or right to the beaches. So there you have New Jersey. Now let's talk about a case from Oregon. So the Thornton versus Hay case out of Oregon reaches the same conclusion, but on a different basis, on the basis of custom. When it is used by courts to make decisions, custom normally refers to situations where something has happened for as long as someone can remember. According to the Thornton court, dry sand has been enjoyed by the general public as, quote, a recreational adjunct of the wet sand or foreshore area, end quote, since the beginning of the state's history. Indeed, they go back to Aboriginal history, indigenous people. The court goes through thinking about this custom, the Blackstonian elements of custom. So what are these elements? So according to Blackstone, custom is long-standing, it is continuous, it is peaceable and free from dispute, it is reasonable, it is certain, and it is obligatory or not left to individual determination. It also is in accordance with existing law. The key measure of custom, the rule of thumb for custom rather, is the notion that no one else can remember anything different. This decision might raise some questions for you. What happens if custom changes? What if the beach itself changes? As we know, shorelines are not forever fixed. We have sea level rise eroding coasts all over the country. What if customs are different from beach to beach? So this Oregon Supreme Court answered the last question, saying its ruling applies from beach to beach. If public access isn't customary for that particular beach, it won't be opened to the public. So it's a tailored custom approach that we see in Oregon. So third case, I will turn to Connecticut, and this is a 2001 case, Leydon versus Town of Greenwich. If you don't think law students can make a difference, consider the fact that Brendan Leydon, who is the plaintiff in this case, was a law student when he brought it. It went all the way to the Connecticut Supreme Court. It essentially held that the beachfront of an exclusive town like Greenwich is like a public park, and therefore all people should have access to it. The case rested on the public trust doctrine, the subject of another video, as well as the First Amendment and the right of laden and similarly situated potential beachgoers to exchange ideas with other park users. The Leydon case started the slow process, which is ongoing to this day, of opening beachfront access for public use. As we all know, there is more to access than just the right to enter onto the beach itself. In the case of Connecticut, you see along the Connecticut coast in community after community, access fees for non-residents, sometimes 10 times more than for residents. You also see parking permit fees and parking prohibitions near the beach that prevent more expanded access by the public generally. So on that Connecticut point, I recommend this book by Andrew Carl. It's called Free the Beaches. It's about a movement to liberate Connecticut beaches from the exclusion and exclusivity that they long exercised. So I will leave it there. I'd love to hear from you, whether on Twitter or through my mailing list or through some other means. I'm happy to hear from you too. See you next time.